a video game lawyer, and I do a lot of things in the video game community. I run a practice out of Chicago called Loading Law that focuses on all the issues that apply to game developers. I do intellectual property, I do contract law, I do IP registrations, all the business needs that let you focus on your game and making creative content instead of having to worry about legal stuff. That's what I do. In addition to my law practice, I also am the vice chair of IGDA Chicago, which here you guys call IGDA, which is kind of cool. I also teach a course on video game law at DePaul University, and I am the board president of the VGA Art Gallery, which you may have seen out on the floor. Anytime you take any photos today of this or do any tweeting, my Twitter handle is @LoadingLaw, and you can check out my website, Loading Law, as well. So before I get started, I always have to do a legal disclaimer. Lawyers love disclaimers. I always have to say that I am a lawyer, but I am not your lawyer, not yet anyway. So we don't have any attorney-client privilege, and everything that I'm giving today is legal information, not legal advice. So it's always good to keep in mind that even though I'm laying out a lot of common principles today that might apply to what you're doing, you might have unique circumstances that might change the way the law applies to you. So it's always good to find someone local or someone who's going to speak directly to your personal issues if you have specific legal questions. So part of what I'm talking today is just a roundup of what actually happened this year in video game law. There were a lot of cases that came down, a lot of high-profile trademark filings, a lot of new things that are going to change the way that the laws apply to video games coming up. And then later in the talk, more specifically, I'm going to dig really deep on copyright and fair use and PewDiePie, which came up quite a bit. So I'll get started there. For those of you who might not know, PewDiePie has had a couple very public gaffes lately where he's gotten into some hot water. Specifically, he was doing, most recently anyway, he had a playthrough of PUBG where he dropped an N-bomb on his live stream. People were very upset about it. He ruffled a lot of feathers in the process. And the makers of Firewatch filed a DMCA takedown notice with YouTube for his review of their game, unrelated to the PUBG review that he was doing. They did so because they didn't want him being associated with their brand. They felt that someone who says those kinds of things in their stream was not in line with their values, not in line with their branding, and they used copyright as a tool to have that video taken down. Now, previously, they kind of had a policy of letting people use their content in videos for review purposes, for streaming purposes, because like most streamers, they enjoyed the benefit of that free marketing. They enjoyed getting their image out that way and having more people see their content. The problem, though, is that they didn't have a hard written agreement about how he could use that content, how people can use that content. It's kind of a friendly, unwritten relationship. So what do you do in those situations where you kind of have a handshake agreement with people to use your content, but you don't have any hard rules about the ways that they can use the content? So here they use copyright as a way to take it down. And that is something that they are well within their rights to do that. Copyright can be used that way under the Digital Millennium Copyright Act. Now, but that being said, it is kind of frowned upon in the copyright community because that's not what that law was initially supposed to protect. Copyright is supposed to protect people using your expressive works, not necessarily what they're saying about your expressive works. And I'll get into that a little bit later when I really start diving into fair use and copyright. Another thing that happened this year that wasn't very high profile was Blizzard ran into some hot water with the MLB, where they rolled out a new logo for their Overwatch League, and it looked somewhat similar to the Major League Baseball logo. Now, when you file a trademark, you give it to the USPTO, the United States Patent and Trademark Office, and before it is officially registered with them, they kind of put out a press release in what they call their official gazette. It's a publication that puts out all of the marks that are about to be granted, and it gives other businesses, other people, and other trademark owners an opportunity to file an objection, to say like, no, that's actually similar to our brand, we don't think that you should register it. So in this case, the MLB didn't file an objection, but they filed a good way to put it, a request for an extension of time to file an objection, which usually means they just found out about it, they have a problem with it, but they haven't been able to sufficiently articulate it yet. So they filed that, and it delayed this logo from being registered a little bit longer. Now, I think as recently as a couple weeks ago, they haven't done anything with it, and the mark seems like it's going to issue. But that was kind of a high-profile trademark issue that came up for a very high-profile game that a lot of us are very familiar with. How many of you guys like Markiplier? Markiplier fans out there? I know it's more than one. You're just tired, guys. Someone who is not Markiplier tried to trademark the name Markiplier. I don't know why people do this. Trademark trolls are a very real thing. Markiplier, I don't think he knows about it yet. I know about it, so he should. I found it on Google. So keep an eye out for that because he might be having something to say about it soon. Here's another one. How many of you currently have any games in development? Or how many of you break the slides? Okay, I'm having so many tech problems today. All right. How many hands are up? It's a good chunk. Game cloning is one of the things that keeps me the most busy, especially when it comes to my mobile clients. So lately, Riot Games sued a Chinese developer for a mobile game clone of League of Legends. And this developer is kind of tenacious when it comes to making clones of League of Legends. They've taken the same game and renamed it and resubmitted it to app stores on 3 separate occasions. And Riot Games recently sued them and won a judgment to get the game pulled and also were awarded very large damages. Now, some of these next ones here, not as high profile. This Lance case was a Supreme Court case that it changed a long-standing doctrine for the way the USPTO handles trademarks. Traditionally, the USPTO wouldn't register marks for vulgar marks, for obscene marks, things like swears or racial slurs they wouldn't register. And the Supreme Court case re-examined that question, and now they've dialed it back where they are going to allow vulgar marks or obscene marks in particular contexts. So in the case here, it actually had nothing to do with video games, but it had to do with a band that was called the Slants, which was a band of people of Asian descent kind of reclaiming that traditionally ethnic slur. And in that case, since the context of the way they were using that slur was changing its meaning and kind of being used in a positive way, the USPTO was reevaluating whether or not they had any input on whether or not that speech was permissible. So they said that they now will register those kinds of marks. And this is going to be important for Washington Redskins and lots of other major brands. And it comes into video games quite a bit as well because right after this, there was just this giant swell of people trying to trademark vulgar terms. Lots of people trying to get a trademark on swastikas or various ethnic slurs, which in gamer culture, just in terms of the vocabulary that a lot of gamers use, especially when they're rage quitting, might become an issue in the coming years. How many of you play emulators? Use emulators or on your PC? It might be getting a little bit harder in the near future because Nintendo has been strictly enforcing the use of ROMs lately. Predominantly because I think they're very much getting into that market now with the mini SNES and mini NES. They don't want people to be able to go out and put those ROMs for those emulated games on Raspberry Pis, for example. So they recently sued a Canadian company that had released an adapter that allowed you to play homebrew games on your 3DS. And I use the word homebrew deliberately because that was the way that this product was marketed. It was supposed to be for developers, for programmers developing their own titles, and this was an adapter that let them play it on the 3DS. That was how the thing was marketed. In reality, most people used it to play ROMs for other games on their 3DS. So Nintendo kind of shut that one down. How many of you have been to my talks in previous years? Like a couple years ago. Awesome, I love seeing people coming back. I've been talking about Lindsay Lohan for like 5 years now. I don't want to talk about Lindsay Lohan anymore. I'm so sick of this Grand Theft Auto case, but it's not dead yet. The latest update that I can give you on that one was the judge in New York had, as of last year, dismissed the case and thrown it out and thought it was finally done. But she's appealing, and they allowed the appeal. So it's going to come back, so when I'm here next year, maybe I'll finally be able to say, we know what you can do and not do when it comes to write-up publicity and Lindsay Lohan and Grand Theft Auto. Someday, fingers crossed. And the last one that I'm going to do here was kind of an interesting one because it didn't involve just US law or Australian law or European law. It involved an international treaty, specifically the Geneva Convention. For any of you who play Halo or basically any game that involves a health pack, you might not know, you're not allowed to use the Red Cross symbol ever. Like the Red Cross has a lockdown on the Red Cross symbol, and they were recently deciding they were going to go after video games who had health packs in them with those red crosses. So if you have a game in development, you're going to use health packs, use something different than a red cross symbol. So I touched on this a little bit earlier, but I'll elaborate here. So I need to stop kicking this HDMI cable. PewDiePie did a bad thing. He said a bad word, and that was not cool. So Firewatch, Campo Santo specifically, the makers of Firewatch, issued a DMCA takedown. How many of you know? Did I lose it again? Yeah, previously? Come on.
Back.
It's back. Step away very carefully.
Move to the microphone.
I'm so sorry, guys. Okay, they filed a DMCA takedown. How many of you know what the DMCA is? Copyright Act. It's a piece of U.S. law that controls how copyright is handled on the internet. It's a very important thing, and it was passed in 1998, the initial version of it. It's been revised a couple times, but we're really testing its limits on how you can use copyrights. And what happened here was Campo Santo didn't like what PewDiePie said. They didn't want that review to be out anymore, so they sent a notice and takedown through YouTube. Now, what's interesting about this is that YouTube's own terms and service policy under the DMCA says if you get 3 of these strikes, you could lose your channel indefinitely, and YouTube will delete all of your content. If PewDiePie lost all, that's a lot of videos for someone like PewDiePie. And the debate that everyone's having right now is, okay, this is what happened. It can happen, but should it happen? Should we allow this kind of thing to happen? So the broader questions when folks ask me, like, what's going on with the DMCA is when, where, and how can you use third-party content in games and video? How's it used? What laws cover it? What are some good business practices? And what's the industry going to do about these changing attitudes? Legal basics. I'm not going to get into trademark, patent, or right of publicity so much right now, but this is what is copyright? It is an original work of authorship fixed in a tangible medium of expression. When it comes to YouTube, that means the video, it means the audio, it means all of the pictures, and in the game, all of those things still apply. Something I have to remind people is that it lasts a very long time. In the case of copyright, it lasts the life of the author plus 70 years if you make it yourself for yourself. That means that your average video game, the oldest video game, it would be copyright protectable would probably be early 1980s, even though games have been around longer. Let's use the 80s as an example. That means those early arcade games that we all love, like Pac-Man, won't be in the public domain and won't be usable for everyone until 2050-ish. Long time from now. So if you are planning a sequel to a game, it's still going to be copyright protectable. And one of the nice things about copyright, in contrast to those other forms of law, is that you technically don't have to register your copyright. It's automatic. As soon as you make it, you have an interest in that work, and you can have a copyright in it. Now, even though you don't have to register, there's some advantages to registering. So for example, if you want to sue someone for copyright infringement, you do have to have a registration with the Library of Congress. Filing a copyright is very, very simple. You can do it from the Library of Congress website itself, and it's either $35 or $55, depending on the kind of work that you're registering. Now, when I talk about copyright, everybody always comes back to me with fair use. They say, well, what is it? How can I use it? I'm not using all of it, I'm not monetizing it, or I only use 10 seconds of something, isn't that okay? And I always have to say, like, dial it back a little bit, slow down, slow your roll. What is fair use really? Fair use is an affirmative defense to copyright infringement. What that means is, if you are using something that you didn't make, technically it could be copyright infringement, but for you to say, well, it's fair use, you have to already be in court, they've already sued you, you've already spent money and hired a lawyer, and you're in court now, and then you have to say, yes, I did commit copyright infringement, so you're conceding the point that yes, you did, and then you say, but it was fair use. You don't want to ever get to that point. That's not a good point to be in. A much better thing to say was, no, I didn't infringe. That comes a lot sooner. So don't rely on fair use right out of the box. Now, some of the most common examples of fair use we see every day. When you read a newspaper and they use a photo of a football game, or if they are using a video clip from a game, sometimes it's fair use. And there's a couple factors that can help you figure out if that use is fair. And one of the biggest, I love that the Cantina song is playing next door right now. Just took me right out of this moment. I'm diving deep into law, and I'm like, oh man, we're in Tatooine. This is great. 4 factors for fair use. The most important one is the first one. Purpose and character of the use, including whether or not the use is commercial or for nonprofit purposes. That doesn't mean that if you're not making money that it's not infringing. You can have a very unsuccessful game that doesn't make any money that is just full of copyright infringing works. But if you're very successful and you're making a lot of money, there's a much better chance that someone's going to come after you. Second, the nature of the copyrighted work. If it's for educational purposes, for example, as opposed to commercial ones, that's going to weigh more in your favor of it being a fair use. The amount and substantiability of the portion used. So how much of the work are you using? Now, there's not a metric on this that says if you only use 10% or if you only use 30 seconds of a song, like there's not an equation where you can use a certain part and it's okay. This is just something that they take into effect. One of the most famous cases that determined the situation was, it was in the late 70s, a newscast broadcast. You guys, now people can hear me, awesome. A broadcast was showing footage from a local circus that was in town. And one of the acts that they showed was the human cannon, the guy launching himself out of the cannon. Well, they showed a 30-second clip, which doesn't sound like a lot, but it was literally the whole act. It was the guy being shot out of the cannon and then hitting the wall and doing his thing. And that's not a huge amount of time, but since it was the whole act and it's the whole reason that people go to see him, he was able to say, well, they saw the best part of my show. Now they're not going to come to the circus and see me because they saw it already. That's affecting my business, that's affecting my money. What's that?
We get you to hold the mic.
Yeah, we can do that. All right, how's that? Is that better? Most non-committal stare about it. And that has to do with the effect of the potential market for a game. So if you're taking away someone's entire opportunity to monetize something, that's going to be a major factor. Fan games and derivative works. In video games, this is where it always comes up. Hacks and mods, remakes, sequels and clones, exploits, parodies, that. This is where copyright infringement happens most commonly for video games because people want to make cool creative things, but they also want to draw on their influences or understand development of games by emulating work that's been done already. I'm going to come back to this one, so we're going to move forward one. Hacks and mods. These are 2 of my favorite ones. Phantom Sonic is a fan homebrew game version of Sonic the Hedgehog that is just the most metal Sonic you've ever seen. And Super Mario Crossover is another one. They did a palette swap where you could play as multiple characters in the Mario game. So you could play as Mega Man, you could play as Contra, you could play as Samus from Metroid. And all of those were copyright infringing because they were borrowing from other brands that are still very much copyright protectable. Remakes, sequels, and clones. I was talking about this a little bit earlier. Metroid 2, this was a fan game based on the original Metroid. It was a really good version. Like, when I first saw it, I was like, oh my God, they made a sequel to Metroid. No, they didn't. This was a total fan game, but it was that good. So what that meant was Nintendo got very angry because I'm a huge Metroid fan, but I couldn't tell the difference if this was official or not. So that was always a problem. Like, fans and mods, fan games and mods are not always bad. Sometimes they're really, really good, and that's almost more problematic because if they're really bad, you're not tarnishing their brand in the sense that people think that it's official. You can do it 2 ways. If you make a really good game, then people think that it's official, and now you're causing confusion in the marketplace over where something comes from. If you make something that's really bad, they know that it's not official, but now you're still dragging down the name with your bad product. So it's kind of a double-edged sword. You can do a really good job or a really bad job, but either way, still illegal, not good. Exploits, this is just another version of this. Does anyone still play Pokemon Go? Oh my gosh, that is the most people I've seen lately. I've given this talk a couple times in the last few months, and usually I get like 1 holdout in the back, and there's actually like 5 people here. That's Team Instinct, awesome. So you remember Pokevision then. So that was just out for a little while, and that was an exploit on the game. After I hear fair use, people always talk about parody, satire. The game on the left, Oregon Trail, how many people have played Oregon Trail? Awesome zombie version of Oregon Trail. The difference between parody and satire, parody uses a work to make fun of the work itself. Satire uses a work to make fun of something else. So in this case, Oregon Trail is obviously about Oregon Trail, but with the zombie pun involved. So it's a parody because it's something funny that's making fun of the original work, Oregon Trail. Satire uses a work to make fun of something outside of the game itself. So if Oregon Trail is a parody, then Mario Kills Tanuki is a satire game. Is anybody familiar with that one? This one wasn't as popular, it wasn't around very long, but this was a game that was actually made by PETA, and they were offended at the whole notion of Mario wearing fur in any of his games. So the game that they made was you have a red panda who is a giant bloody red panda chasing Mario to get his skin back. It's a very political statement, and satire usually is political. So a lot of SNL episodes, even though they're funny, they're usually satiric more than they're funny. And Weirder Stuff is actually a game that I made during a game jam last year. I'm a big fan of Stranger Things. I'm really excited for season 2. And I wanted to make a game that really walked the line with satire. So in my game, Weirder Stuff, not Stranger Things, instead of going to the upside down, you go to the inside out. The character who would be Elle is actually called L-E-L-L-E. And instead of Eggos, she, I think, eats hot dogs. She eats something else. But that would be an example of a satire. Now, a distinction when I talk about fair use, because people use the term very colloquially. It seems like when non-lawyers talk to me about fair use, they have it tied up in like a moral conception, like I used it and I think it was fair, it's a fair use. When I talk about fair use, it's a legal term of art because it's an actual affirmative defense. It has a legal definition that's a little bit different from the way that everybody else uses it. This is kind of my wrap-up slide on fair use. I always like to leave a lot of time because I want to take specific questions from all of you more than this. So I feel like I've kind of skirted around fair use, but I've given you a general working definition of what it is and how it works. Always remember it's an affirmative defense and it's a last defense. It's not something you want to open the door with.